Good morning, everyone. My name is Damian Williams, and I'm the U.S. Attorney for the Southern District of New York. When I was sworn in as U.S. Attorney, I promised that this office would be relentless in rooting out corruption in our financial markets. And that means rooting out corruption wherever it may be happening in our markets, and moving quickly to investigate and prosecute so that people understand that there are swift and serious consequences for bad conduct. I think it's fair to say that we've had our hands full during my tenure, especially in the aftermath of the sudden collapse of the crypto economy. The implosion began in May of 2022 with the collapse of the Terra blockchain and the disappearance of billions of dollars in investor value. Since then, my office has exposed many of the industry's biggest actors as frauds. We brought cases alleging insider trading in digital assets, manipulation of the market for crypto tokens, criminal exploits of smart contracts, and investor fraud at the core of some of crypto's biggest players. And each day this week alone, my office has announced criminal charges shedding light on fraud in the cryptocurrency and digital asset ecosystem. On Monday, we announced charges against a defendant who allegedly used an old-school technique known as spoofing to create a website that impersonated OpenSea, the world's largest marketplace for NFTs, and to steal NFTs and cryptocurrency from unsuspecting victims who thought they were giving credentials to the real OpenSea. On Tuesday, we announced charges against a defendant who we allege used his expertise as a senior security engineer at an international technology company to steal approximately $9 million from a decentralized cryptocurrency exchange. These were the first criminal charges ever brought involving an attack on a smart contract on a decentralized cryptocurrency exchange. And just yesterday, we announced charges against two defendants, a father-son duo, who allegedly engaged in a scheme to steal money from sophisticated and novice investors alike by offering a variety of fraudulent cryptocurrency-related investment services. This was simply old-school, old-fashioned fraud where the defendants made allegedly false promises about crypto to get money from victim after victim, which they then allegedly used to fund a lavish lifestyle. And now today, I'm joined by our law enforcement partners to announce another significant step in our drive to root out corruption in the crypto economy. Exactly 1 year ago today, Celsius Network, a crypto platform that, at its height, managed approximately $25 billion in customer assets, filed for bankruptcy protection here in the Southern District of New York. And over the course of the past year, we've worked quickly to get to the bottom of what led to Celsius's collapse, to understand how a platform that advertised itself as, quote, the safest place for your crypto could have left investors holding billions of dollars in losses. Today, we have the answer. Today, I'm announcing the unsealing of an indictment charging Celsius's founder and CEO, Alex Mashinsky, with orchestrating a scheme to defraud customers of Celsius through a series of false claims about the fundamental safety and security of the Celsius platform, and for participating in a scheme with Celsius's chief revenue officer, Rani Cohen-Pavone, to inflate the price of Celsius's proprietary token, CEL. Together, these schemes allegedly allowed Mashinsky to mislead customers by presenting Celsius as a safe and reliable alternative to traditional banking institutions when, in fact, from its inception, Celsius was taking far greater risks with customers' money than Mashinsky advertised. We allege that while Mashinsky was lying about the true risk of providing crypto assets to Celsius, he was also causing the public to purchase CEL at inflated prices. This personally benefited Mashinsky because he was secretly selling his own CEL tokens at prices he knew did not reflect the token's market value. We allege that Mashinsky repeatedly claimed that he was not selling his CEL when, in reality, he was selling huge quantities on the open market, lining his own pockets to the tune of $42 million. In addition to the charges against Mashinsky and Cohen-Pavone, I'm also announcing that we've entered into a non-prosecution agreement with Celsius itself that reaffirms the commitment of the company's new management to maximize the recovery for victims and to cooperate with our efforts to hold those responsible for this fraud accountable. The cases we've announced over the course of this week may all be different, and the allegations may be complicated, but the message is simple. If you lie, cheat, or steal, or if you rip off ordinary investors to line your own pockets, we will hold you accountable. Whether it's old school fraud or some new school crypto scheme, it doesn't matter one bit. It's all fraud to us, and we'll be here to catch it. Now, bringing a case of this complexity requires close coordination with our law enforcement partners, And I want to thank our incredible partners at the FBI for their work on this investigation, as well as our partners at the SEC and CFTC who brought parallel civil actions today for their cooperation and hard work on this and so many other cases in this space. Finally, I want to thank the career prosecutors from my office who are handling the prosecution, Noah Solowaychik, Allison Nichols, and Adam Hobson, as well as their supervisors, Scott Hartman and Matthew Podolsky, the chiefs of our Securities and Commodities Fraud Task Force. I now want to invite up to the podium FBI Special Agent in Charge, Michael Brodak.
Thank you, Damian, and good morning. My name is Michael Brodak. I'm the FBI Special Agent in Charge of the New York office's Criminal Division. This case highlights the great work and outstanding partnerships shared by the agencies represented here today. As the indictment alleges, Mashinsky and Cohen Pavan knowingly engaged in multiple complex financial crime schemes while serving in leadership roles at Celsius. As alleged, in large part due to the false portrayal of Celsius by Mashinsky, the company became one of the leading operators in crypto, and both defendants were fraudulently manipulating the value of Celsius's proprietary crypto token, CEL. With the price of CEL propped up, they then sold their personal holdings of the token for significant gain. Mashinsky earned more than $40 million, while Cohen Pavan netted about $3.6 million. This case is yet another example of what we see too often with complex financial fraud cases. When something seems too good to be true, it probably is. The FBI will continue to ensure that anyone committing fraud and deceiving the public through the misrepresentations of a business's financial standing or practice is held accountable. Through the actions today, the FBI hopes to be able to give the customers of Celsius, the victims, some measure of justice. I'd like to thank, for their partnership, U.S. Attorney for the Southern District of New York, Damian Williams, Southern District Securities and Commodities Fraud Task Force, the Securities and Exchange Commission, the Commodity Futures Trading Commission, and the special agents, intelligence professionals, and forensic accountants of FBI New York office's Securities Fraud Team. Thank you.
I'd now like to welcome to the podium Gurbir Grewal, Director of Enforcement at the SEC.
Thank you, Damian, and good morning, everyone. Today, in a parallel civil complaint, the SEC also filed charges against Celsius Network Limited and Alexander Mashinsky. We allege that they engaged in an elaborate fraud involving hundreds of thousands of investors and at its peak, over $28 billion in assets on the company's balance sheet. As alleged in our complaint, there were multiple aspects to defendants' scheme. First, they falsely promised investors, quote, financial freedom. They promised them, quote, economic opportunity. And they promised them safe crypto investments with high returns through their earned interest program. Second, they misled investors about the viability of Celsius's business, often completely fabricating their financials. And third, they fraudulently manipulated the price of Celsius's own crypto asset security, the so-called CEL token. Ultimately, the defendants' elaborate crypto fraud collapsed of its own weight when their lies and other fraudulent conduct could no longer prop up the Celsius platform and its offerings. And when it collapsed, unfortunately, it left thousands of investors lined up at the doors of a bankruptcy court, hoping for some recovery of their lost investments. Today, along with our federal partners, we're holding Mashinsky and Celsius responsible for their lies and for their deceit. Now, the U.S. Attorney has detailed aspects of the scheme. I'd like to share a few more that are relevant to the charges brought by the SEC this morning. We've alleged that Celsius and Mashinsky made numerous false and misleading statements to induce investors to purchase CEL and to invest in the earned interest program. Among other things, they misrepresented Celsius's central business model and the risks to investors by claiming that Celsius didn't make uncollateralized loans, that it didn't engage in risky trading practices, but in reality, it did all of those things. We also allege that Celsius and Mashinsky misrepresented Celsius's financial success, to make the company appear more successful and stable than it was. In fact, by the spring of 2022, even though they knew that Celsius was failing, Celsius and Mashinsky continued to prop it up by telling the investing public a very different story, claiming that, quote, all user funds are safe, and that Celsius, quote, continues to be open for business as usual. Again, the reality here was much different. Celsius had approximately $1.2 billion more in liabilities than assets on its balance sheet at the time it filed for bankruptcy. As we detail in our complaint, defendants also manipulated the market for the CEL token by, among other things, publicly touting a buyback program where Celsius purchased the amount of CEL needed to make interest payments to investors. But again, reality was much different. Celsius bought, at Mashinsky's direction, millions of dollars of additional CEL to bolster its price and to induce other investors to buy it. As part of these efforts, they timed their CEL purchases to have the greatest market impact. Now, the misconduct here is yet another example of the need for crypto market participants to come into compliance with our securities laws. Those laws are in place to provide critical protections to investors. Those protections include robust rulebooks that help prevent fraud and manipulation. Those protections encourage proper disclosures, and those protections require routine inspections by the SEC. None of those protections were available to the investing public with respect to Celsius's offerings. And this case provides yet another stark reminder of the consequences of noncompliance in the crypto markets. I'd like to recognize the SEC team that worked on this matter. Randall Friedland, Christian Eskuntz investigated the matter under the supervision of Pei Chung, Stacy Bogert, David Hirsch, and Jorge Tenrero. Sachin Varma, Peter Rosario, and Adam Gottlieb assisted in our investigation. And H.B. Roback will lead the litigation against Mashinsky under the supervision of James Conner and Olivia Che. Finally, I'd also like to thank our law enforcement partners this morning, the U.S. Attorney's Office for the Southern District of New York, the FBI, the Commodities Future Trading Commission, and others for their assistance in this investigation. And with that, let me turn it back to the U.S. Attorney.
I'd like to invite up to the podium CFTC Enforcement Director Ian McGinley.
Thank you, Damien, and good morning. Today's actions are testament to law enforcement's shared commitment to promoting integrity in the cryptocurrency and financial markets. For our part, this morning, the CFTC announced the filing of charges against Celsius and its former CEO, Alexander Mashinsky. While this is the first case the CFTC has brought against a crypto lending platform, our allegations are all too familiar for those paying attention. First, our complaint alleges that the defendants defrauded customers in commodities markets by making outlandish claims about returns and the safety of investments. These lies induced investors to deposit commodities in their accounts, which the company then deployed to make risky and ultimately failed investments. Outsized returns with no risk. As my colleague from the FBI said, that is too good to be true, whether you're talking crypto or traditional finance. Mashinsky's lies did not end there. He lied about numerous aspects of Celsius's business. He claimed he was not selling Celsius's digital token, stating in May 2022, "I'm holding, I didn't sell." In reality, that month he sold approximately $2 million worth of the tokens. As Celsius was collapsing in May 2022, with customers withdrawing at a record pace, he claimed Celsius is stronger than ever in order to solicit new customers. And in June 2022, he said, Celsius has billions in liquidity. Anyone who wants to withdraw has no problems. 2 days later, Celsius stopped all withdrawals. Mashinsky made numerous of these false statements during Ask Mashinsky Anything videos that were live streamed. And while viewers could ask Mashinsky anything, he could not say just anything. He had to tell the truth, and he didn't. Instead, he lied, and that is fraud, plain and simple. Second, we allege, in addition to committing fraud, the defendants failed to register with the CFTC for operating a commodity investment pool. In plain English, that means Celsius collected customer assets and used them to trade commodity interests, including in the futures markets, like gold futures. And like any entity involved in this type of trading, Celsius was required by law to register with the CFTC. And these registration requirements, they may sound bureaucratic, but it is not just paperwork. They are vital to the CFTC's oversight responsibilities precisely to protect investors, like the investors in this case, by providing standardized disclosures, including risk disclosures and an accounting of assets and fees. Finally, I'd like to end by thanking the CFTC staff that worked tirelessly on this case: Dmitry Valinsky, Crystal Ganella, Jason Gizzarelli, Jonah McCarthy, Tracy Rodriguez, and Paul Hayek. These attorneys were assisted by the CFTC's Digital Asset Task Force, a group of specialized attorneys and investigators focused on digital asset issues. And because of the hard work of these staff and others at the CFTC has now brought about 100 digital asset-related cases. And today, as I said in the beginning, is another example of our dedication, along with our law enforcement partners, to combating fraud in the cryptocurrency markets. And I want to thank the Southern District of New York, the SEC, and the FBI for their partnership in this case and in so many others in this space. Thank you.
Thank you, Ian. Happy to take a few questions.
Where is Colin Pavon and Albert Nice to see?
Well, my understanding is that he is located abroad. He's an Israeli citizen, and that's as much as I can say. Next question.
From the actions you described at the outset and what you've done over the last several months, this whole crypto industry doesn't quite seem to be on the up and up. Is any of this legit or safe, or is the whole industry a fraud?
Well, I want to be careful in how I describe the industry and don't want to go beyond the facts and the investigations that we've had and the charges that we've announced. But I think it is fair to say that we have brought a number of actions, and our partners at SEC and CFTC have as well, across the entire waterfront of the industry. And I would encourage people who are looking to invest to, of course, do their due diligence. Anything that seems too good to be true, as folks have said before, likely is. And so people should just proceed with caution.
I mean, are you the new sheriff? Are you the sheriff of crypto? Like, what's the...
Your words, not mine.
Well, you could say words.
I think one thing I am very proud of is, of course, over the past year, this office has brought a number of significant cases in this space. I think we've been extremely busy, and that's not by accident. The Southern District of New York has historically been at the forefront of enforcement in any new area. We could roll the clock back and talk about the big accounting fraud scandals. We could talk about the go-go days of insider trading. Those days are still here, unfortunately. But of course, there are new horizons that have been opened up recently, including in the crypto economy and bad conduct that we've seen. And so anytime there's bad conduct, we'll be there.
Luke Cohen,
Thanks. Just building off Aaron's question, are the actions that you've taken so far having any sort of deterrent effect that you're seeing elsewhere in the industry?
Look, it's hard to be able to identify what the deterrent effect is, but our hope is that it is. I mean, every time we announce a new action, we're trying to reinforce the message that if people cross the line, they're going to get caught. And so it should inform people's behavior going forward. They're on notice, and so if they cross the line again, it's they should expect to hear from the Southern District of New York, the FBI, the SEC, and the CFTC. That should be baked into their thinking as they take these actions.
Matt?
Sure, thanks a lot. Matt Sealy, City Press. I wanted to ask you about he hasn't been presented yet in the magistrate's court, so maybe you won't say whether you're seeking detention or release on bond. But I've noticed in some crypto cases, you did seek detention, like Abby Eisenberg, Miles Guo, or Guoc, it may be different. Can you say what's the office's thinking in terms of when to seek detention in these crypto cases and when to allow release on bond?
It's the same thinking that applies to any case, whether it's a traditional fraud case or any other type of charge that we bring. I mean, there are specific factors that we evaluate, and assuming that there is either a risk of flight or potential danger to the community that we can articulate and make out, then we seek detention. And if not, we'll seek a different type of arrangement.
And what's your plan in this case?
I can't get ahead of the facts here. You'll see soon enough. Next question.
Jonathan Deans, NBC.
I was just curious if anyone could share with us the number of victims, the total amount of money lost, and the likelihood of how much you might get back for those victims.
So I don't have the specificity on the numbers on the first two, and on the last, I would say that there's a bankruptcy process going on right now. Our hope is that we'll be able to see a robust recovery for the victims. But that's a process that's more complicated because it, of course, involves the bankruptcy proceedings. Next question.
RSK Analyst,
How
CNN.
many more crypto cases do you have in the pipeline?
I'm not going to open up the books right now. I'll say that we continue to be very busy.
Carol.
I had a question on Gail Buff, the case that you guys brought earlier this week. Do you have any sense of where he is? Is there any possibility of extraditing him?
So just to tweak one aspect of the question. So we brought the case in November of 2022. It has been pending for a while. It's just been under seal for a while. I can't speak to where he is, but of course, anytime we could, bring someone to justice, we try to do that.
Jonathan
I was
Deans,
wondering if I
NBC.
try on the Guo case, there was a fire at the Sherry Netherland. Has that cause been determined? Was it arson or was it accidental?
I don't have anything for you on that right now, but I do know the fire that you are referring to, but I don't have an announcement for you today.
No determination at this time.
I don't have an announcement for you today.
Okay, and if I could ask on the Senator Menendez matter, I was wondering if you can update us. Has the Senate Ethics Committee been advised by your office to either engage or stand down?
I cannot speak to confirm or deny any investigation that we may or may not have, and so I don't have any comment for you on that.
Anyone else? Thanks, everybody.
Thank you.